In the pre-dawn hours of February 3rd, an action unfolded that would send tremors through centuries of royal tradition. Not a declaration of war, not an abdication, but something perhaps more devastating, the institutional erasure of a mother. 2 passports belonging to children of royal blood were locked away in the Tower vaults, placed beyond reach, beyond negotiation, beyond mercy. The Crown had made its judgment, and in doing so it revealed a truth more disturbing than scandal, that sometimes the greatest threat to children comes not from strangers, but from those who gave them life. For Prince Harry, this day arrived at the exact moment he believed the storm had finally passed. Legal documents bore fresh signatures, attorneys had withdrawn to the shadows, the relentless public scrutiny surrounding his children seemed, at minimum on the surface, to be settling into uneasy calm. There was discussion of tentative reconciliation, of cooperative parenting, of finding pathways forward without cameras and courtrooms, but that calm was a fiction. What emerged following that settlement did not create stability. It detonated warnings. Beyond the palace gates, officials started detecting something profoundly disturbing. It wasn't a televised confession. It wasn't a legal challenge. It wasn't even an open accusation. It was disappearance, quietness, a sequence of withdrawals, leaving no documentation and offering no justifications. By the moment the Crown intervened, it was no longer responding to an isolated incident. It was confronting a direction. Within Windsor, a confidential legal notice had materialized mere days before. Its language did not suggest controversy. It transmitted danger signals. Educational connections terminated without warning. Medical consultations systematically cancelled. Communication pathways severed. Organizations charged with protecting children abandoned without responses. What troubled senior counselors most wasn't the actions themselves, but the precision behind their execution. Each maneuver examined independently possessed plausible justification, a shift in education, a timing conflict, a procedural modification, but assembled together, they constructed something undeniable: orchestration. By the moment Princess Anne and Prince William received briefing, the vocabulary had fundamentally transformed. This was no longer characterized as a parental dispute. It was articulated in considerably harsher language. Identity jeopardy, psychological displacement, systematic elimination. At that juncture, the Crown abandoned observation. The passport freeze was not retribution. It was protection. Under royal guardianship doctrine, once children are determined to face removal from their historical and constitutional foundation, intervention becomes compulsory, not discretionary. No media statement accompanied the measure. No clarification was presented to the public. But internally, the communication was unambiguous. The Crown had crossed from monitoring to authority, and then almost simultaneously a second earthquake followed. According to individuals familiar with circumstances, Prince Harry initiated allegations that astonished even veteran palace administrators. Accusations concerning Meghan Markle, accusations concerning Prince Andrew, accusations raised not throughout negotiations, not throughout mediation, but exclusively after control over the children had started sliding beyond grasp. Why vocalize then? Why delay until silence had already triggered the most extreme response available to the monarchy? Those questions persist unanswered. What stands clear is this: the freezing of 2 passports was not the inception of the catastrophe. It was the verification that the catastrophe had already been developing for months, and what the Crown discovered next would eliminate any possibility for compromise. The initial warning did not originate from the palace. It originated from an institution. On January 31st, administrators at 2 exclusive schools in Santa Barbara detected something that instantly violated procedure. Archie and Lilibet did not appear for the new academic period. Initially, it seemed unremarkable. Children are absent, families relocate, calendars shift, but by afternoon, anxieties escalated. There had been no notification of departure, no transition documentation, no clarification provided by a parent, a legal advocate, or an educational coordinator. More concerning still, the institutions had not been notified of any alternative establishment. There was no receiving school identified, no academic progression strategy, nothing. By regulation, such disappearances triggered an institutional examination. Within hours, the circumstance advanced from standard absence to urgent alarm. Personnel attempted to reach Meghan Markle directly. Electronic messages went ignored. Telephone calls were not acknowledged. Communications left with administrative contacts yielded no reply. The schools then contacted the court-designated mediator, supervising the children's welfare under the custody settlement. That department, too, possessed no documentation of a modification. At that instant, the matter crossed a boundary. When children disappear from an educational framework without clarification, and no guardian can be contacted, it is no longer a domestic family situation. It transforms into a protection inquiry. Notifications were distributed. By that night, the situation had escalated to officials linked to international child welfare surveillance, including the United Kingdom coordination team designated to monitor the children's cross-jurisdictional safeguards. What they uncovered only intensified the alarm. There were no travel declarations on record, no revised residency statements, no submissions indicating movement, homeschooling, or private instruction. Even more troubling, there were no recently registered healthcare providers associated with the children. When investigators examined pediatric documentation, the design became sharper. Multiple standard medical consultations had been terminated in swift succession, not rescheduled, not postponed, eliminated completely. No continuation instructions were provided. No care consistency had been established to experienced child protection specialists. This combination was deeply troubling. Children had been extracted from education, medical supervision had been disrupted, and the parent of responsibility was inaccessible. By February 2nd, the character of internal communications shifted dramatically. What had originated as a worry became something approaching emergency. Language employed in official correspondence hardened. Words like supervision and collaboration were supplanted with extraction and impediment. Behind closed doors, attempts were conducted to establish whether this was a momentary oversight or something more calculated. But as time advanced, the lack of clarification began to appear intentional. There was no crisis mentioned, no medical condition reported, no security danger revealed. There was merely silence. Inside Windsor, briefings began distributing among senior administrators. The inquiry was no longer regarding the children's location. It was why so many frameworks had been purposefully disconnected simultaneously. Education, healthcare, legal correspondence. Each element alone might be rationalized. Combined, they established a design that could not be dismissed. A palace insider later characterized the atmosphere with disturbing simplicity. This was not incompetence. This was preparation. By the moment Princess Anne was notified, the matter had already progressed beyond negotiation. It was no longer a question of parental authority. It was an inquiry of whether two children had been positioned into a deliberate vacuum. And once that likelihood exists, royal procedure permits no hesitation. The subsequent action would not involve dialogue. It would involve evidence. The emergency assembly was not arranged through standard protocols. There was no preliminary notification, no briefing document distributed in advance. Senior advisors were commanded to secure the chamber at Windsor Castle within moments. Communications devices were confiscated, staff were excluded. What transpired was not a conversation, it was a revelation. Princess Anne arrived carrying a crimson portfolio. Those who witnessed would later characterize the moment as instantly grave. The portfolio was substantial, secured, and labeled with terminology rarely employed outside the most critical constitutional situations. Immediate custodial violation, maternal extraction, no uncertainty, no diplomatic language. She positioned it on the surface before the king and remained standing. The communication was delivered directly. The family had survived years of public examination, reputational warfare, and private conflict. But what had been revealed now violated a boundary that could not be addressed through forbearance or tolerance. This was no longer concerning appearance, media, storytelling, or personal complaint. It was concerning two children being abandoned in legal and psychological suspension. Inside the portfolio were materials assembled over multiple days by various departments functioning independently, then authenticated collectively. Educational documentation, medical notifications, legal exchanges. Each segment alone generated concern. Together they illustrated a scenario that shocked everyone present. The initial collection of documents detailed the school extractions. They validated what had already activated warnings in California. The children had been removed without official notification. No destination institution had been specified. No substitute education strategy had been filed. Even more disturbing, written directives from Meghan Markle's legal representatives had been transmitted to multiple organizations, explicitly preventing further interaction with royal education coordination. The second segment addressed healthcare. Standard pediatric consultations for both children had been terminated abruptly, not postponed, not rearranged, cancelled comprehensively. There were no subsequent providers documented, no continuity transfers, no emergency justification. In protection terminology, this was regarded as a grave interruption of guardianship responsibility, but it was the financial evidence that transformed the atmosphere from worry to disbelief. A long-established education trust account valued at $6.3 million and initially established to finance the children's future education in the United Kingdom had been liquidated. The documentation was finalized. The assets had been redirected. There was no suggestion that replacement provisions had been created. For experienced palace counselors, this posed a question that could not be overlooked. Why eliminate a child's educational future while concurrently extracting them from school? The explanation, when it materialized, was far more unsettling. The concluding document in the portfolio was an intelligence assessment dated January 29th. It was designated privileged and confidential, and compiled by the Royal Intelligence Advisory Group. Unlike the other materials, this one did not chronicle behaviors. It outlined intention. According to the evaluation, Meghan Markle had invested the preceding 4 months preparing for what analysts characterized as total maternal withdrawal. The assessment did not depend on conjecture. It referenced agreements, correspondence, and strategic planning materials. Among the discoveries was a confidentiality contract with a Dubai-based media investor. The contract stipulated the elimination of all previous family connections ahead of a scheduled independent brand introduction. Language within the agreement emphasized personal transformation and narrative disconnection. There were also internal exchanges declining involvement in Prince Harry's suggested joint custody structure. Documents showed a calculated refusal to commit to co-parenting arrangements beyond the absolute minimum mandated by court directive. Perhaps most revealing were internal agreements connected to Archewell functions. These materials instructed all mentions to Archie and Lilibet to be eliminated from future Spotify and Netflix productions by mid-2026. Their identities, their representations, their existence. To those present, the suggestion was unmistakable. This was not a mother withdrawing temporarily. This was a methodical campaign to eliminate the children from both institutional and public recognition while maintaining complete personal independence. One legal counselor summarized the determination with chilling exactness. This is not co-parenting. This is erasure. At that instant, the conversation concluded. Princess Anne did not solicit perspectives. She did not encourage discussion. She authorized immediate advancement. Duchess Sophie of Edinburgh was directed to implement emergency custodial protection procedures without postponement. A formal investigation documenting alleged maternal withdrawal was initiated immediately. The documentation was arranged for presentation to both the Royal Chancery Court and the California Family Court under collaborative jurisdiction procedures. Simultaneous legal intervention would commence concurrently, guaranteeing no postponement could be manipulated. When Prince William arrived shortly thereafter, he was presented the identical crimson portfolio. Observers later remembered that he examined in silence page after page. No disturbance, no apparent emotion. When he arrived at the concluding document, he glanced up and articulated only once, "This is no longer about her. It is about safeguarding 2 children emotionally, legally, and historically." That declaration would determine everything that ensued, because from that instant forward the Crown was no longer responding to circumstances. It was preparing to act. Once the crimson portfolio was secured, the environment inside Windsor transformed. This was no longer a matter of analysis. The materials had already resolved the most essential question confronting the Crown. The matter was not whether Meghan Markle had withdrawn from active motherhood. It was whether she had been orchestrating to depart completely, abandoning behind not only obligation but legacy. Senior counselors began employing a phrase that possessed exceptional significance within royal frameworks: intention. In protection investigations, intention matters more than perception. Mistakes can be addressed, oversights can be rectified, but calculated withdrawal, especially when combined with strategic orchestration, necessitates intervention. The intelligence assessment dated January 29th became the foundation of the examination. Unlike legal submissions or welfare accounts, it did not chronicle isolated behaviors. It traced a progression. Over a duration of months, analysts witnessed a consistent design of withdrawal that demonstrated a transparent internal rationale. Initially came the subtle reduction of public acknowledgments to the children. References and external communications diminished. Family-centered branding softened, then disappeared. The transformation was subtle enough to evade examination, yet consistent enough to register within monitoring frameworks. Subsequently came contractual reorganization. Communication revealed discussions with a Dubai-based media investor concentrated on establishing a personal enterprise independent of any family story. Preliminary contracts emphasized independence, transformation, and disconnection from historical connections. One provision identified by counselors requested the elimination of all historical markers that could connect future ventures to royal heritage. That alone generated worry, but what transpired next validated intention. In internal communications, Meghan Markle rejected involvement in Prince Harry's suggested joint custody structure. The rejection was not passionate, it was administrative. Language concentrated on reducing responsibilities, restricting coordination, and preventing long-term co-parenting obligations beyond what was strictly enforceable. To royal legal specialists, this indicated preparation for separation, not collaboration. Simultaneously, Archewell-associated materials revealed a coordinated campaign to extract Archie and Lilibet from future media productions. Directions were distributed to guarantee their identities and representations would not feature in forthcoming Spotify or Netflix material after mid-2026. No substitute story was presented. No transitional communication was suggested. It was as if the children were being phased out. What disturbed counselors most was not the ambition underlying these maneuvers. It was the coordination. These preparations coincided exactly with the dismantling of educational and medical frameworks that had stabilized the children's everyday existence. Education withdrawn, healthcare disrupted, identity extracted from public documentation. Considered together, the design indicated something far more critical than professional realignment. It indicated departure. One palace administrator later characterized the understanding as a moment of shared revelation. The Crown was not observing a custody conflict. It was witnessing the preliminary phases of abandonment, executed quietly and systematically. The terminology employed in internal briefings became more severe. Maternal withdrawal, identity displacement, psychological severance. At that phase, royal procedure mandates advancement. Princess Anne authorized Duchess Sophie of Edinburgh to implement emergency custodial protection procedures. This apparatus exists for exactly one objective: to intervene when a royal child's continuity is jeopardized due to the behaviors or inactions of a guardian. The determination was not characterized as punishment. It was characterized as containment. A formal investigation file was initiated, instantly documenting all proof of withdrawal, impediment, and preparatory disengagement. The documentation was organized to survive examination under both United Kingdom and California family law criteria. Simultaneous jurisdiction would guarantee no postponement, no escape, and no uncertainty. Timing mattered. Within hours, the Royal Chancery Court was alerted. So too was the California Family Court, designated to supervise the children's protection. Both were notified that the Crown was prepared to exercise emergency power if circumstances deteriorated. Meanwhile, Prince Harry remained largely excluded from these proceedings. Reports indicate that he was notified only after the structure had been established. His standing, while emotionally meaningful, had become legally peripheral. Counselors noted unresolved residency matters, financial uncertainty, and the lack of independent infrastructure capable of sustaining complete guardianship. For the Crown, the assessment was unambiguous. Two children could not remain suspended between withdrawal on one side and instability on the other. They required structure, they required certainty, they required protection that did not depend on cooperation, When Prince William arrived and examined the intelligence assessment in full, the conversation narrowed to a single inquiry. How far was the Crown prepared to advance? The response came swiftly. This was not about controlling public reaction. It was not about managing narrative. It was about maintaining identity. The children were not commodities. They were not representations. They were individuals born into an institution that possesses responsibilities as much as privilege. One councillor stated it directly: if the Crown failed to intervene now, it would be complicit in their erasure. That evaluation eliminated uncertainty. From that instant forward, planning transformed from examination to implementation. Legal apparatus long dormant were reactivated. Historical precedents were re-evaluated. Emergency provisions drafted decades earlier were restored into application. The Crown was preparing to execute something it had prevented for generations, assume direct obligation. And when that determination was completed, there would be no partial actions. There would be no discussion. There would be intervention. The critical moment arrived without fanfare. There was no declaration, no public examination, and no attempt to minimize the ramifications. Once the proof of calculated withdrawal had been confirmed, the apparatus of the Crown began to advance with quiet exactness. Prince William returned to Windsor under circumstances that insiders later characterized as immediate and mandatory. An emergency assembly of the Royal Advisory Council was assembled behind secured doors. Participation was restricted to senior constitutional councillors, child protection experts, and members of the Privy Council authorized under emergency procedure. This was not a platform for conversation, it was a platform for resolution. The central inquiry placed before the Council was unambiguous. Were Archie and Lilibet experiencing a level of displacement that warranted direct royal intervention? The proof was examined one final occasion: educational extraction without progression. Medical supervision disrupted, financial protections dismantled. Strategic preparations arranged to extract the children from both institutional and public recognition. A parent inaccessible, a secondary guardian unable to establish stability. There was no disagreement. The Council reached complete consensus that the boundary had been violated. At that instant, Prince William invoked a provision that had remained inactive since the abdication catastrophe of Edward VIII. Recognized internally as Appendix 4 of the Royal Succession Stabilization Act, the provision permits the Crown to assume guardianship when royal minors experience identity displacement, legal abandonment, or psychological damage arising from custodial breakdown. The invocation possessed exceptional gravity. It was not symbolic. It was functional. Within hours, protective actions were implemented across multiple jurisdictions. The children's passports were positioned under instant security limitation, preventing any international movement without dual authorization from Princess Anne and the Crown's Child Welfare Council. This was not characterized as confinement. It was characterized as containment, guaranteeing that children could not be relocated beyond reach while legal proceedings were proceeding. Simultaneously, an image protection directive was distributed under the Windsor Privacy Act for a duration of 5 years. Any commercial or promotional exploitation of the children's identities, representations, or stories was prohibited without explicit Crown authorization. Streaming platforms, publishers, and licensing associates were notified through legal pathways. The communication was unmistakable. The children were not merchandise. Then arrived the financial response. Prince William authorized the establishment of a royal restoration account valued at $12 million. Its objective was not public relations. It was restoration. The account was allocated to psychological stabilization, educational progression, and long-term reintegration within a protected setting. Therapists specializing in cross-cultural identity trauma were secured. Educational strategists were charged with reconstructing structure without disruption. This was not a temporary solution. It was a long perspective. As these actions developed, Prince Harry submitted a petition for temporary custodial power. According to multiple reports, the petition was examined and rejected within hours. The justification was administrative, not personal. Unresolved residency matters, travel restrictions, inadequate independent capabilities to satisfy protection criteria. The determination was transmitted without elaboration. Custody, guardianship, and protection of Windsor children now resided solely under Crown procedure. By nightfall, the intervention was finalized. Frameworks were secured. Directives were submitted. External associates were alerted. No disclosures occurred. No media briefings transpired. The lack of spectacle was calculated. For the monarchy, this was not about demonstrating dominance. It was about executing responsibility. One senior counselor later summarized the moment with quiet seriousness. The crown did not remove the children. It intervened because no one else could be trusted to maintain the boundary. Yet even as authority was confirmed, those inside Windsor recognized that this was not the conclusion of the catastrophe. It was the beginning of its most unstable phase, because while the crown had intervened with power, one figure remained completely outside the new structure. Meghan Markle had not acknowledged, and the quietness that transpired would soon communicate louder than any opposition ever could. While Windsor advanced with discipline and restraint, Meghan Markle advanced in the reverse direction, or rather, she did not advance at all. In the hours following the Crown's intervention, petitions for explanation were transmitted through official legal pathways. They were acknowledged, then abandoned unanswered. Declarations were composed, modified, and ultimately suppressed. What emerged instead was quietness, calculated and absolute. For palace administrators, this lack of acknowledgement was more informative than any public rejection. As legal directives took effect, ramifications began materializing beyond the boundaries of Windsor. International associates were alerted of the image protection mandate. Streaming platforms quietly revised internal compliance notifications. Acknowledgements to the children were extracted from archive descriptions, promotional materials, and future development frameworks. No declaration clarified the modifications. The identities simply disappeared. Behind the scenes, financial supervisors in multiple jurisdictions initiated precautionary restrictions on accounts connected to holding frameworks associated with Meghan Markle's media enterprises. The interventions were not retributive, they were protective, activated by unresolved custodial power and potential exploitation of minors' identities. Sponsorship discussions connected to family-oriented storytelling ventures stalled, then disintegrated completely. What had once been characterized as transformation now appeared like separation. Reports soon materialized, positioning Meghan aboard a luxury vessel in Doha, photographed in the presence of a Middle Eastern media investor. To the external world, the photographs suggested assurance and liberation. To those monitoring the circumstance, they validated separation, not just geographic but psychological. No inquiries were conducted about the children's whereabouts. No official challenges were submitted against the guardianship actions. No appeal was presented within the critical preliminary window when influence might still have mattered. Inside royal briefings, the comparison was observed with discomfort. While frameworks were activated to stabilize two young existences, the primary parent of responsibility remained inaccessible. Prince Harry, by comparison, was very much visible. According to individuals within his circle, he was shocked by the velocity and finality of the Crown's interventions. He had believed that custody settlements, once authorized, offered security. He had believed that compromise would be adequate. He was mistaken. When he petitioned temporary custodial power, the acknowledgement was immediate and analytical. His residency condition in the United States remained unresolved. Travel restrictions complicated jurisdictional supervision. Financial uncertainty posed protection worries. None of these elements were moral evaluations. They were administrative obstacles. The communication delivered to him was exact and unemotional. Guardianship demanded structure. Structure demanded capability. At that instant, he did not satisfy the criterion. The correspondence conveying the determination was delivered by royal courier. It contained no elaboration, no consolation, and no regret. Custody, guardianship, and protection of Windsor children would persist solely under Crown procedure until additional notification. Any future interaction would be provisional, monitored, and subject to examination. For Prince Harry, it represented a devastating understanding. He was no longer the authority, he was a witness. As these developments materialized, another transformation occurred quietly within the palace. Obligation for the children's everyday psychological welfare was reassigned. Princess Catherine assumed a role that demanded no declaration. She modified her calendar. Experts were secured. A trusted guardian with extensive experience in cross-cultural identity challenges was reassigned to assist Lilibet directly. The methodology was careful and understated. There were no arranged moments, no theatrical gestures. Stability was restored through consistency, not spectacle. One small instant, however, possessed profound symbolism. A single photograph was distributed to the media without description or clarification. It displayed Lilibet walking out of Windsor Chapel, holding Princess Charlotte's hand. No elaboration transpired. None was necessary. To the public it appeared tender. To those who comprehended the foundation, it was conclusive. The children were no longer adrift, they were grounded. As for Meghan Markle, her legal representatives eventually distributed a brief declaration citing privacy worries and ongoing proceedings. It contained no acknowledgement to the children's welfare, no consolation, no recognition of the actions taken in their identity. Within Windsor, the response was restrained but determined. Quietness, when combined with abandonment, is not neutrality. It is validation. And with that validation, the Crown prepared for the subsequent phase, because guardianship had been confirmed, but evaluation had not yet been delivered. While legal apparatus tightened and power consolidated, something else materialized inside the palace, far from courtrooms and secured directives. It was quieter, slower, and far more significant. The Crown comprehended that guardianship alone could not restore what had been disrupted. Protection without belonging is only containment. What the children needed now was not just security, but progression. A recognition that their existences had not been reduced to legal submissions or institutional worry. That obligation fell deliberately and carefully to the subsequent generation. Within days of the guardianship transition, Princess Anne authorized a series of understated actions designed to restore psychological stability. No media releases declared them, no calendars were disclosed. Each action was taken as if it were standard, even though nothing about the instant was ordinary. Lilibet was introduced into a structured everyday rhythm inside Windsor. Instructions resumed quietly. Recreation was reintroduced without agenda. Familiar consistencies replaced instability. The emphasis was not on discipline, but on consolation. Princess Catherine supervised the procedure personally. Her participation was not symbolic. She coordinated with child psychologists experienced in identity disruption and displacement. She insisted on consistency over intensity, normalcy over narrative. The objective was not to clarify the catastrophe to a child, but to eliminate the recognition that existence itself had become unstable. Those closest to the procedure characterized Catherine's methodology as calculated restraint, no dramatics, no forced connection, just existence. And then arrived Princess Charlotte. The determination to include her was not impulsive. It was examined carefully among senior counselors and child protection experts. Charlotte was not requested to perform. She was not commanded to represent anything. She was simply encouraged to be what she already was, family. The two girls were introduced gradually through collaborative consistencies rather than official assemblies, meals, walks, quiet instants where dialogue was voluntary. No cameras, no expectations. What emerged was organic. Charlotte, already accustomed to the rhythms of royal existence, became a point of calm, not through power, but through familiarity. There was no hierarchy imposed, no clarification demanded, just companionship. One palace advisor later witnessed that this was the most important phase of the entire intervention. Legal power could be imposed in an instant. Psychological trust could not. As days advanced, the transformation was observable. Lilibet's anxiety diminished. Her sleep designs stabilized. Her illustrations, once characterized as fragmented and unsettled, softened in character. These details were documented quietly by specialists, not communicated publicly. Inside Windsor, there was a developing recognition that something fragile had been captured before it fractured. That comprehension shaped the subsequent maneuver. On the morning of Candlemas Eve, Kensington Palace distributed a single photograph to the media. There was no declaration attached, no description, no clarification. It displayed Lilibet and Princess Charlotte walking out of Windsor Chapel together, hand in hand. To casual witnesses, it was a tender representation. To those observing closely, it possessed unmistakable significance. Progression had been restored. The communication was not about triumph or vindication. It was about inheritance in its truest definition. Not titles, not wealth, but belonging. Inside the palace, councillors observed the exactness of the coordination. The photograph materialized just as legal submissions intensified across jurisdictions, just as speculation reached its peak, just as the story threatened to spiral beyond authority. The Crown did not counter speculation with language. It countered it with reality. Two children grounded in family, one future protected quietly. And in that instant, it became transparent that the catastrophe had transformed. This was no longer a story about Meghan Markle's decisions. It was a story about what transpires when an institution determines that children are not collateral. They are the boundary itself. The subsequent phase would not be shaped by passion. It would be shaped by evaluation. The judgment did not arrive with spectacle. There was no dramatic courtroom scene, no elevated voices, no final moment appeals. When evaluation finally arrived, it materialized the way the Crown prefers its most significant acts to materialize: quietly, officially, irreversibly. On the morning of February 1st, the court assembled under circumstances of exceptional restraint. Proceedings were concise. Arguments were restricted. Proof already extensive was acknowledged without challenge. Meghan Markle was not visible. Her legal representatives validated that she would no longer participate in the session. That lack spoke louder than any resistance. The determination that transpired was historic. Meghan Markle was officially stripped of all custodial power over Archie and Lilibet. The evaluation cited sustained withdrawal, impediment of welfare supervision, and calculated severance of educational and medical progression. In legal terminology, it was characterized as abandonment through omission, rather than behavior. Within hours, Princess Anne addressed the situation in a rare live declaration from St. James's Palace. Her language was calibrated but unmistakable. Any official influence Meghan Markle may assert over Windsor children is hereby null and void. The Crown no longer acknowledges any maternal privileges previously granted. The protection of these children must reflect responsibility, not ambition. There was no challenge from across the Atlantic. What transpired was a cascade of institutional ramifications. Trust frameworks previously confirmed outside royal supervision were restricted and dismantled. Financial mechanisms connected to the children's identities were declared invalid under the Windsor Accords. Commercial contracts referencing Archie or Lilibet were terminated without exception. The children's identities were positioned under complete royal protection, shielded from licensing, branding, or monetization of any character. Then arrived the most conclusive action of all. By official mandate of Prince William, distributed under a sovereign guardianship apparatus, last employed during the abdication catastrophe of the 1930s, both children's passports were positioned into permanent royal security custody. Until reaching maturity, they would not depart the United Kingdom without direct authorization from the Crown. This was not characterized as limitation, it was characterized as preservation. At the same moment, a classified intervention quietly advanced into effect. Coordinated through the Foreign Office and Child Protection Powers, a small team was dispatched to California. Their mandate was exact. Document circumstances, guarantee compliance, secure all remaining legal connections if necessary, retrieve. The intervention possessed an internal designation that revealed its intention: dandelion, resilient, rooted, impossible to eliminate once confirmed. As this materialized, Meghan Markle was photographed in Doha attending private assemblies with media investors. Representations circulated briefly, then diminished. Her legal advocates distributed a short declaration disputing jurisdiction and asserting privacy. It contained no acknowledgement to the children, no opposition to the judgment, no commitment of return. Within royal circles, the quietness was comprehended. Meanwhile, those once regarded allies began to separate themselves. High-profile supporters demanded clarifications that never arrived. Scheduled ventures stalled. A suggested podcast reintroduction was quietly withdrawn after focus assemblies characterized it as psychologically detached and inauthentic. The story Meghan Markle had hoped to reconstruct collapsed under its own lack. Prince Harry, for his portion, withdrew from public observation. Appearances were terminated, invitations rejected. Those familiar with him characterized a man captured between shock and remorse, struggling to comprehend how swiftly power had advanced beyond his grasp. and yet the Crown did not characterize this as punishment. In a clarification distributed by the Privy Council, it was declared directly, the monarchy is not correcting people, it is correcting direction. Obligation for Archie and Lilibet now resides with Princess Anne, Prince William, Princess Catherine, and Prince Edward as designated trustees. Their mandate is singular: protection, stability, progression. Inside Windsor, existence resumed. Instructions continued. Meals were distributed, gardens were walked. The exceptional was folded gently into consistency. There were no victory declarations, no proclamations of triumph. Only structure, only care. Only the quiet assertion that children born into legacy will not be abandoned to convenience. One inquiry, however, remained unresolved. Why did Prince Harry vocalize with shocking allegations only after custody had already been eliminated? Why did assertions involving Meghan Markle and Prince Andrew materialize only when power slipped away? Those responses have not yet emerged. And until they do, this story is not concluded. Because the Crown has intervened, the children are protected, but the truth behind the final rupture has yet to be